The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome, everyone. Thanks for joining us for today's webinar, an update on Section 409A and Deferred Compensation. The webinar will last approximately 15 to 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sujas. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Limberg, and Linus regularly speaks at industry events. His new book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available for sale. If you are interested in purchasing this book, please contact us. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks very much, Jennifer, and welcome everyone. I guess I have to apologize in advance if Jennifer and I sound a little bit breathless. Like you, we've been answering questions about the new Secure Act, and it's got us plenty busy, and that's a good thing. We are going to talk about the Secure Act next month. Normally we have a poll here to decide on a topic, but we don't need to run the poll. We know what the what the request would be. So what I would ask you to do is that if you've got questions about the Secure Act, things that you would like to know more about, send us a little note in the chat window in the webinar, or send us an email after the session today, and let us know what it is specifically about the Secure Act that you would hope that we would cover in a webinar. We want to let you know that we intend to have a 1-hour webinar on the Secure Act. 1 hour is hardly enough, but we'll do our best to put the Secure Act into a 1-hour crash course next month on February 5th. So mark your calendars and help us out with by letting us know what it is that you'd like for us to emphasize during that 1-hour session. Today we're going to talk about Section 409A and deferred compensation. We're going to talk about that in the context of the Safelite case. It was an interesting case, which I think underscores some of the pitfalls with regard to deferred compensation and some of the ways that we often hear about agents getting deferred compensation wrong. So let's start with a little bit of background about deferred compensation and cover what we think most people already understand, and that is deferred compensation is a way to provide an incentive to an employee. There are many types. People mean all kinds of things when they talk about deferred compensation, but any type of deferred compensation has the potential to be subject to Code Section 409A. The requirements of 409A and the penalties for failure to conform with 409A really are the centerpiece of what we want to talk about today. For those on the call, if you're talking to somebody about deferred compensation, more likely than not, you're going to be talking to them about deferred comp that has characteristics that are similar to bonus plans, and also center around the use of permanent life insurance as the informal funding vehicle for the promises that are made under the plan. Almost always we're talking about all employer money in the deferred comp plan. We're not talking about the employee putting in any money. The employee is not deferring compensation, but the employer is saying to the employee, I'm going to pay you later on for work that you do today, and that's the deferred compensation element. So, as I said earlier, the many on the call are thinking about deferred compensation as an alternative to a bonus plan. A couple of the great things about bonus plans are their simplicity and the fact that they generate a tax deduction for the business right now. The downside is that the business owner loses control of the amount that is contributed to the bonus arrangement, and that usually is something that they want to avoid. While it is possible to keep a lot of control with a SERP kind of deferred compensation plan. How does that work? Well, the company ends into a promise, a written contract to pay the employee later on if the employee fulfills certain conditions, such as remaining with the business until retirement. Now, it's important to note, and I'll say this several times during the call, that this is a contractual obligation to pay on the part of the employer. It is not directly tied to life insurance. And a lot of the callers that we get kind of get that part of it mixed up. They think that the life insurance is the deferred compensation plan. It is not. It is the contract between the employer and the employee. So there's this contract in place drafted by an attorney that under which the business promises to pay the employee later on. Well, the business, in order to keep its promise to pay the employee later on, may put money aside, and commonly that money is put aside in a permanent life insurance policy. Why permanent life insurance? Well, permanent life insurance grows tax deferred. It generates cash value that can be used to help make sure that the money is available to pay the benefit later on. And the cash value and the death benefit are available to help the employer recover any costs associated with making this promise to the employee. The SERP plan often involves life insurance. The life insurance policy is owned by the business. The life insurance policy has the business as the named beneficiary. When an employee retires, the business uses the cash value it has available to it to make a payout to the employee under the terms of the contract. If the insured dies, the insured key employee dies, the business uses the death benefit to recover its costs and to pay out any additional benefits associated with death that may be payable to the employee and the employee's family. So the policy is owned by the business, and as I said, the benefit is available to the business to help make sure that the payout is available. There are various types of employer paid deferred comp that can fall into the SERP category. It is possible for an employer to pay the employee only in the event of a pre-retirement death. That is called a DBO plan, a death benefit only plan. It's possible for the employer to plan to pay the employee in a stream of income in a for-profit company. That would be set forth in the agreement at the front end. The plan may provide for a lump sum payment at retirement, may provide for a period of years, but the important part is that those things are decided up front. There's a lot of flexibility, but those things need to be set up in the agreement at the beginning. They are not things that generally can be decided later on. What are the tax characteristics of SERPs? Well, SERPs got two main features that are important to, at least to the callers that we get about deferred compensation. The first thing is that when the employer sets aside money to help pay for the retirement benefit later or the death benefit later, the employer does not get a tax deduction for the life insurance premiums if life insurance is used as the funding vehicle. The employer is able to deduct amounts that are used to pay the benefits at retirement or other triggering event. That's the good part from the employer's perspective. Of course, the employee has to include the amount that is paid to himself or to his family when the benefit is received in the employee's taxable income. So there is no free lunch. Income tax must be paid. There is no tax deduction on the front end. And so those things combined together really mean that a SERP is not a good fit for the owner of the company generally. You're generally talking about a non-owner employee who is going to be a candidate for a SERP implementation. Now, there are a lot of complexities associated with SERPs and other forms of deferred comp. Constructive receipt and substantial risk of forfeiture complexities have existed for a long time. And since 2005, we've got Section 409A issues. So let's talk about those things just a little bit. Constructive receipt. So under the IRS's rule of constructive receipt, the taxpayer is liable for income tax associated with stuff over which he has control but has not yet taken possession of. What does that mean in a work environment? Well, if an employee is entitled to receive something, even if the employee hasn't yet taken possession of it, the employee has to treat the amount provided by the employer for his benefit as income at the time that he has access to it. So, it's one of the reasons why having the life insurance be owned by the business and being controlled by the business is important. We have the deferred compensation agreement as an unsecured promise to pay the employee, not tied to the life insurance. If we tied them together, we'd be worried about the constructive receipt issue and the immediate income tax result for the employee. Likewise, we have a substantial risk of forfeiture rule. The IRS says that if an employee is entitled to a benefit and can't lose that benefit, then it's like it was received in cash. And so that's why we talk about deferred compensation being subject to the claims of the employer's creditors. It's an unsecured promise that the employer is going to pay the employee later on, and the employee is at risk that if the business goes belly up, that the employee won't be paid. And that's how we deal with the substantial risk of forfeiture requirement for deferring compensation. Well, since 2005, we've got another worry, and that's Section 409A. 409A is fairly heavy duty and needs to be thought about in every kind of deferred compensation situation. The IRS encouraged Congress to add Section 409A in response to perceived abuses in deferred compensation. The IRS felt like employers and employees had too much flexibility over the timing of deduction and inclusion in income, and so it implemented the 409A rules with regard to deferred comp. And it's, I think, important to start with the penalty. And the penalty is that if you screw up 409A, the employee gets taxed immediately on whatever is due and whatever the plan is going to pay the employee, and there's an additional 20% penalty tax with possible interest, and those penalties are pretty severe. So that's why we pay so much attention to Section 409A. Well, what are the technical requirements of 409A? The first one is the most important to a lot of the callers, or a lot of the people on this call perhaps, and that is the plan needs to be in writing. If you could ever have done a deferred comp plan without a deferred comp document, it can't be done anymore because that violates the requirements of Section 409A. What is deferred comp for Section 409A? Virtually anything where the employer promises to pay the employee later on, except within a short time frame. The plan has to provide for only permissible payments that can be made on the following triggers: separation from service, disability, or death, a fixed time in the future under a fixed schedule, or a change in ownership in the business. Those are the limited triggers for a deferred compensation payout. If you pay out without following those triggers, you're violating Section 409A. So in addition to that, 409A has some other technical provisions in it. First of all, it can't permit a participant to accelerate the timing of a benefit. What do I mean? Well, if the original agreement says the participant is going to be paid in equal installments over 15 years, beginning at retirement age, they can't decide later on that, oh no, the participant's going to get all the money up front just by asking for it. Second thing is the plan may not be administered in a way that's inconsistent with provisions of the agreement. And if those rules aren't followed, the participant pays immediate income tax on the value of the benefit plus an additional 20%. And I think it's interesting for all of us to note that the penalty is imposed on the participant, not on the employer. And so it's in the employee participant's best interest to make sure that the employer is following all the requirements of Section 409A. Otherwise, the employee is the one that's going to get hit with a bad result. And in fact, that's the source of the angst that was raised by the Safelite case. So what happened in the Safelite case? Well, it was a Sixth Circuit case where Safelite's president, Dan Wilson, sued the company because Dan said the company didn't properly administer the deferred compensation plan. Well, what was the deferred compensation plan? In 2005, Safelite's board of directors created a plan that provided for a bonus in the event of a change of control for the company. In 2006, there was a potential for a change in control. So the board decided to adopt a deferred compensation plan so that the executives could put off recognition of those bonuses into the future. And so what did the plan provide? Well, the key provision for us is that there were two timing options about the timing of the payout. And it could be done in a lump sum in the event of a triggering event or in annual payments over a period of 10 years. And that kind of choice was really not permitted under Section 409A. So even though Wilson participated in the plan and deferred hundreds of thousands of dollars into the plan over the course of time, in 2014, the IRS audited his return and decided that the plan that he was participating in did not meet Section 409A's requirements, and that Wilson owed income taxes on the amounts deferred, any earnings, and of course substantial tax penalties, not the least of which is the extra 20% penalty tax. Well, Wilson was understandably upset. He sued the company for breach of contract and for negligent misrepresentation. The company moved for summary judgment, arguing that his claims were preempted by ERISA. And the district court granted summary judgment, and Wilson appealed to the Sixth Circuit, and Sixth Circuit affirmed that ERISA controlled the situation. Now, it's interesting that the district court and appeals court did not say that Wilson had no rights to try to collect against Safelite. They only said that the rights to collect were limited to the remedies provided under ERISA. And so I expect that since we're now 15 years from Section 409A's implementation, we'll probably see more of these lawsuits where the IRS's audited executives found that they're participating in deferred comp plans that don't qualify under ERISA, and that the executives end up suing their former employers for money associated with the tax liability and the penalties. And so I feel certain we'll see more of that. So what are the lessons for us? Well, the first one is compliance with Section 409A is really, really important. There are severe penalties for failing to properly be down that path. The second thing is that the IRS, based on the evidence of Wilson, is apparently reviewing employers' Section 409A compliance. And where an employer doesn't comply with 409A, it ends up being a bad result for the employees, and that may lead to litigation. And I guess the last point I'll mention on this slide is that you got to be careful, right? If you're helping your client implement deferred comp, CERP variation of deferred comp, or any kind of plan that has a deferred comp element, you better take them to a lawyer and make sure that they're complying with the requirements of Section 409A. We've seen in our office a lot of situations where restricted bonus plans and buy-sell arrangements have deferred compensation elements embedded in them that if the parties knew about 409A or were made aware during an audit, they'd lead to unexpected tax results. And for those of us who are life insurance professionals and financial professionals, helping our clients avoid those pitfalls, I think, is in all of our best interests. And then I mentioned this earlier. Deferred comp plans, including CERPs, need to be drafted by attorneys. I know it's tempting for an agent to try to do this on their own. They think that the life insurance by itself can be administered like a deferred comp plan. It cannot. If the IRS gets wind of it, the client will be made famous like the executive here in the Safelite case, and that's certainly something that we don't want. So our company is Advanced Underwriting Consultants. We provide advanced sales services to agencies and to life insurance carriers. You can reach us by email. If you have suggestions for next month's webinar on the Secure Act, please either put it in the chat window or email us. And at this point, I will turn the program back over to Jennifer to close us out. Jennifer?
Thanks, Linus, and thanks for joining us for today. And please join us for next month's webinar on the Secure Act on February 5th. As a reminder, if you would like to receive supporting materials about today's webinar, feel welcome to email me at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar to me. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultations and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.